Ladies and gentlemen, your honors, welcome to the National Constitution Center. We are so thrilled to have you for this great conference on the future of the regulatory state. I am Jeffrey Rosen, the president of this wonderful institution. And as our loyal members know, we begin every program here by reciting the inspiring mandate from Congress that created this place during the bicentennial of the Constitution. And that mandate is to disseminate information about the U.S. Constitution on a nonpartisan basis. Very good. You see how well-trained our great members are? And for those judges who haven't been here before, I'm really thrilled, along with my colleague Jeremy Fogel, to introduce you to this place and enlist you in this inspiring, crucial mission of civic education. In these polarized times, this is the one place in the country that brings together citizens, judges, students of all ages and all perspectives to debate and educate themselves about this beautiful document of human freedom, which unites us, which is the U.S. Constitution. We're going to jump right into this panel, but I need to begin with a plug for a thrilling new online platform that I want you to know about if you haven't encountered it already, and I want you to cite it in your opinions, because I think you will find it as extraordinarily elucidating as I do. And it's called the Interactive Constitution, and you can get it in the App Store. Not now, because I'm talking, but after the show, you can download it or find it online. Since it launched a year ago, it's gotten 9 million hits. It's co-sponsored by the Federalist Society and the American Constitution Society, which co-chair the advisory board that created it. And on that advisory board are also our distinguished panelists today, Randy Barnett and Elizabeth Wydra. And using this thrilling free tool, which the College Board has made the center of the new AP History and Government exams, you can click on any clause of the Constitution. The three that Randy did are the Ninth Amendment, the Commerce Clause, and an essay about federalism. But we can pick a nice uncontroversial one to demonstrate it, like the Second Amendment. And we can click on the Second Amendment and find the two leading scholars of the Second Amendment nominated by the Federalist Society and the American Constitution Society, Nelson Lund and Adam Winkler, with a 1,000-word statement about what they agree the Second Amendment means, and then separate 1,000-word statements about what they disagree. So isn't that thrilling? It's like an en banc majority opinion. Every word in that common statement is mooted on and agreed on by both scholars. And Randy was discussing how exciting it was to write with scholars like Heather Gerken of Yale Law School or Mike Seidman of Georgetown, with whom he has many disagreements, a common consensus statement about what the Commerce Clause means. So I just think it is thrilling in these polarized times judicially. One of our goals in this conference is to model civil discourse between people of different perspectives, to have these extraordinary tools which show how much consensus there is in the law and history, as well as the ability respectfully to disagree. All right, let's jump right into our really important subject today, which is the future of the regulatory state. Randy and Elizabeth are, the whole program is dazzling. We've got the finest scholars and judges throughout the next 2 days. But I think it's fair to say that Randy Barnett has done more to transform the debate about the proper scope of the Commerce Clause and the regulatory state than any other scholar in America. And you can find a distillation of his thoughts in his wonderful and accessible new book, Our Republican Constitution, Securing the Liberty and Sovereignty of the People, which he came to the Constitution Center to discuss last year, and we just had a superb discussion. And it will be a touchstone for our discussion of his arguments that much of the current post-New Deal administrative state is unconstitutional. And his interlocutor is the superb and dynamic visionary leader of the Constitutional Accountability Center in Washington, Elizabeth Wydra. Elizabeth, our great partner at the National Constitution Center on so many issues, runs an extraordinarily important think tank and advocacy center that files briefs and makes arguments that the original understanding of the Constitution, applied in a principled way, should in many cases favor progressive rather than conservative results. And in that sense, she has herself both helped to transform the debate about the relevance of text in history as an ideal interlocutor for Randy. So we've got a lot to talk about in about 40 minutes, and that is the constitutionality of the regulatory state. And Randy, let me just jump right in. In your great book, you say there are two visions of the Constitution: the democratic Constitution, which says first comes government and then comes rights, and the Republican Constitution, which says first comes rights and then comes government. Tell us about the Republican Constitution and why you believe the framers would have considered the current administrative state unconstitutional.
Well, thanks, Jeff, and it's a great pleasure to be here. This place just wasn't doing much of anything until Jeff Rosen took the leadership of it, and now it's a place to be proud of. And so I'm just always pleased to participate here, and Elizabeth and I have debated many times, as well as worked on briefs together in the McDonald case. So actually, the script that I was given, I was expecting to talk about the origins of the separation of powers.
Oh, well, we can start with that then. What the heck? Let's start with the origins.
That's
really what I meant, with the origins of the separation.
I mean, not that I don't like to talk about my book, Our Republican Constitution, but...
we'll get to that later, but tell us what the framers' conception of the separation of powers.
So the separation of powers starts with the buried idea of why we have a government in the first place. So some of you know there was a political philosopher named Thomas Hobbes and a political philosopher named John Locke. They both had what they call state of nature theories, which is, in a state of nature, why would we need to form a government? And Hobbes' theory was, in a state of nature, everybody was at liberty to do everything they willed, and you actually needed the government to constrain liberty and to establish rights. But the founders were not Hobbesians, they were Lockeans, and Lockean wrote after Hobbes, and Locke's conception of the state of nature was a bit different. Locke's conception of the state of nature was, in the state of nature, there were rights. Everybody had a right to do, everybody had the liberty to do what they will with what's rightfully theirs. But in the state of nature, he said, was inconvenient. It was inconvenient in three different ways that corresponds to the separation of powers. The first way is that there was no known and standing law. And therefore, people who wanted to do the right thing might not be able to do the right thing because they really wouldn't know what the law or justice required of them. And so you needed to have someone to produce a known and standing law, which would give rise to, for example, what he called the legislative power. The second thing there were no impartial arbitrators in the state of nature. Anybody who got into a dispute with each other would have to be the judge in their own case, and because we're all partial towards ourselves, this was likely to lead to bad results as well as perpetual conflicts, because it was the absence of an impartial tribunal of justice or an impartial adjudicator, and this gave rise to the need to have a judiciary. And finally, in a state of nature where you do have rights, you have to enforce your own rights, and people aren't always able to enforce their own rights, especially against the power of a group who, no matter how strong an individual you are, you're not strong enough to withstand the power of many. And so what was needed was an executive power. And this is where the concept of the three separate powers became theorized and imported into America: the legislative, executive, and judicial powers. But Locke himself did not talk that much about the separation of these powers amongst different people, because in fact in England these powers were combined, and he was writing about the English system that he knew about. This is a concept that was introduced to the Americans by a man named Montesquieu, who was a Frenchman, and in his book, The Spirit of the Laws, he wrote about how it was very, very important that each one of these separate functions be performed by separate people. And by separating the powers into separate people, that would help protect liberty. This was an idea that was, in fact, adopted by the founders. It was actually put into the Massachusetts Constitution, and I thought I would read the section of the Massachusetts Constitution, it's in my book, that talks about this. It's just a passage. It says, in the government of this Commonwealth, and this was written by John Adams, in the government of this Commonwealth, the legislative department shall never exercise the executive and judicial powers, or either of them. The executive shall never exercise the legislative and judicial powers, or either of them, and the judicial shall never exercise the legislative and executive powers, or either of them, to the end that this may be a government of laws and not of men, which is the origin of that phrase. And some of you may recognize that phrase because it was cited by Justice Scalia in his dissenting opinion in the Morrison v. Olson independent counsel case, where he was the only person who dissented from the consensus of the court that said an independent counsel, independent of control of the separation of powers, was perfectly constitutional. It was his formalist originalist understanding of separation of powers that led him to the right answer, in my opinion, that an independent counsel was a very bad idea, which it proved to be and eventually was gotten rid of. So that's the origin of the separation of powers. In the Constitution, powers are not strictly separated. We also have a separate concept called checks and balances, which is not quite the same thing as separation. Powers, in some sense, have to be combined in order to be checked. So, for example, you have the Senate today playing an important role in vetting the persons who the executive branch wants to have as their officers. Today is the hearings for Senator Jeff Sessions to be Attorney General. So the Senate plays a role in that. The Senate approves treaties. The President has a legislative capacity of vetoing legislation as a way of checking legislative power, but it was always thought that the veto power was a legislative type power as opposed to an executive power. So there is some intermixing in the Constitution, but by and large, that is how we got a separation of powers, and that is why we have a separation of powers. And the final thing I would say, like Massachusetts, this was all meant not to protect the powers of each branch. So this wasn't for the benefit of Congress, and this was not for the benefit, so that the separation of powers would thereby preserve structurally the liberties of we the people.
That is beautifully said. It's a perfect introduction. And forgive me for scrolling because you mentioned the Massachusetts Constitution, which you can also find on the thrilling interactive Constitution, which in addition to the features I mentioned, allows you to click on any part of the Bill of Rights and see its historic antecedents among the Revolutionary era state constitutions, like Massachusetts and Virginia, as well as the proposals that were made but not adopted. And one of Madison's unadopted proposals essentially mimicked the Massachusetts Constitution and said the legislature may not exercise judicial powers and so forth. So it was a separation of powers like amendment. One of our a visiting congressional scholar from the Senate at the National Constitution Center, we have Senator Mike Lee and Chris Coons are our bipartisan visiting scholars, and Mike Lee saw that great provision and said, imagine how much mischief would have been avoided in the federal government if Madison's proposal had been passed. Elizabeth, I really want to engage. So Randy's given us the philosophical underpinnings. The framers were Lockeans. They did read Montesquieu. On the other hand, you argue that they were not minimalists. They were Hamiltonians, and you cite Resolution 6 offered to the Constitutional Convention, which provided that Congress could legislate in all cases for the general interest of the Union and also in those to which the states are separately incompetent. So essentially, what is your response to Randy's notion that although the framers were Lockeans, they nevertheless did not embrace a strictly enumerated vision of federal power?
Well, I think, first of all, I want to thank you for inviting me and thank all of you for being here. It's always a pleasure for me to be at the National Constitution Center and for the Constitutional Accountability Center to partner with the NCC on so many of these great programs. And I will also put in a plug for the Interactive Constitution, not just to this room, because one of the things I think is wonderful about it is that it's concise. And even though it is not dumbed down in any way, it's very accessible. So not just to the people in this room and the august judges that we have assembled here, but also for those of you at home who are watching who, you don't have to go to law school. You don't have to, be sophisticated in the law as a scholarly subject to be able to understand the Constitution. And the Interactive Constitution app goes a long way, I think, toward that type of civic education that is needed now more than ever on the Constitution. And I think Randy's description of the philosophical origins gets us to your question, because you have the Aristotelian idea of these three functions of government, which were then translated in Montesquieu into this separation of powers idea, that you should have institutions doing each separate thing. But then the question, of course, is why? And the idea that you have separation of powers and you set up a government that way, and the reason why the founders were thinking about this and thinking about Montesquieu and Locke, is because they wanted to protect liberty, and they wanted to set up a government that would perpetuate democracy and liberty and a functioning government. And so I think that last point makes us think about, well, what was their experience prior to coming together and writing the Constitution? They had the colonial government, they had the British government, which had too strong executive, whether it was a monarch in England or a colonial imposed governor in the colonies, where the governor was picked by the British, had control over, in many cases, the legislature. It was too strongly executive. There was a reaction against that in the Articles of Confederation after Declaration of Independence, where you only had a legislative branch. You had a Congress that was made up of state delegations, but it couldn't really even though you only had that legislature, you didn't have an executive, Congress still couldn't really do much. They couldn't pass laws that had impact in state courts. They couldn't levy taxes. They had to ask the states for money. In fact, on that last point, George Washington said that it was such an ineffectual system that it nearly cost the colonies, the newly declared independent colonies, it nearly cost them the Revolutionary War because they could not get the money that they needed for their troops. So when they come with that experience in mind, the over-energetic executive, tyrannical executive that they saw in England and with the colonial government, the dysfunctional Articles of Confederation that were perhaps too limited in their scope, they came together to say, we're going to follow these principles of a separation of government with 3 branches in Article 1, 2, and 3, including an energetic Congress that has broad powers, like they wrote when the Committee of Detail was tasked with interpreting what those powers would be, including regulating commerce, all sorts of important aspects that the fledgling nation wanted to make sure they had an effective, functioning government that could take care of, as well as this innovative executive branch that would have a president, that would have powers that were not there under the Articles of Confederation. And the idea was that they wanted to create a government that was capable of providing national solutions to national problems in these new United States of America. And in making that effective government, they also, of course, were always guided by this idea of liberty and democracy. And so the ways that the branches intersect with each other in constitutional structure is really, obviously I'm a big common law nerd, so I'm going to think this, but it's really beautiful. You have the overlap of powers. You have the checks and balances. You have these systems that are set in place to try to make sure that our representatives, no matter which branch of government they're in, are dependent upon the people alone, not upon special interests. So you have very specific ways of doing that. The judicial branch gets life tenure, so they are not suspect to the whims of appointing authority once they get on the bench. You have the Congress, who has staggered election terms. In the original Constitution, the Senate was, the senators were put forth by state legislators, and the House was elected by the people. So the idea is that you had different bases of authority and different elections at different times. So you couldn't have one kind of wave of influence. They were particularly concerned about foreign influence at that time, which again is something that has come up in the news lately, but that was throughout both the Constitutional Convention and in the state ratifying conventions of concern. And then also these other aspects for the president, the way that his salary and that executive officials would get their salary, the emoluments clause about not being able to get gifts from foreign governments, again, something that's been in the news. So the way that it all works together to promote the people's liberty and the people's representatives, I think is really part of the genius of our constitutional structure.
Beautifully said. Thank you for that. Randy, one of the arguments of your powerful book is that things went really wrong during the progressive era, and that the combination of innovations like direct election of senators and the rise of the fledgling administrative state created an unaccountable series of institutions that the framers would have repudiated. It's interesting, in the light, I'm saying this descriptively, in the light of the recent election, that many progressives are reconsidering some of the elements of direct democracy that they exalted during the progressive era, including the powerful unitary executive, and are calling on Congress once again to exercise its constitutional duties. So we may be seeing a bipartisan revival of Madisonianism. But I do want to, I guess the criticism of the book is that it makes perfect sense as an application of Lockean theory to the New Deal administrative state. But it's ahistorical because it ignores what happened in between the framing and the progressive era and afterward. And Jerry Mashaw has a quite wonderful history of the administrative state, where he notes a series of 19th century innovations from Jefferson's embargo, which was an extraordinary exertion of unitary executive authority, to the establishment of the post office where the framers and their successors did delegate lots of authority on a presidential level to uncongressionally created institutions. So what about that history?
Well, Jeff, when I was the lawyer for Angel Raich in the Gonzalez versus Raich medical marijuana challenge that went to the Supreme Court, one of my talking points when I was the lawyer for the several years of that, you need to talk to the media, and one of my talking points was that, federalism is not just for conservatives. Unfortunately, we could not convince the liberal side of the court to rule for us in the medical marijuana case and allow California to go its own way in authorizing medical use of marijuana. But now I welcome my progressive friends to the. We've
been litigating progressive federalism for years and years and years.
I mean, she is the exception and you know that you are somewhat exceptional on the left. It's one reason why the CAC is such a great organization. But I'm going to welcome, I welcome my liberal friends now to the value of checks and balances. We're going to rediscover a lot about separation of powers and checks and balances and the lack of deference. Anyway, let me just say a little bit about the rise of the administrative state that I do talk about in my book. Woodrow Wilson and other progressives were just not a fan of separation of powers and checks and balances. In fact, Wilson himself, who was one of the leading progressive theorists before he became president, analogized society, as most all the progressives did, to a body. They thought the society was like an organism. And of course, you notice when people have organism metaphors, guess who gets to be the brain of the organism they have in mind? It's always them. And guess who gets to be the little fingers in the appendages? That's like the little people. Because you can always do away with the little people, a finger. You can get away without a finger, but you can never get away without the brain. And so the people who are developed in this organism, they're always the brain. Anyway, so the brains, the brainy people, the progressives, they wanted rule by experts, basically, and they weren't all that happy. They wanted efficient government, they wanted powerful government, and if they wanted things decided on the national level, they weren't all that happy with federalism either. And they didn't like separation of powers because it was like checks and balances. What Wilson said is, it's like, the human body is a beautiful organism, and you don't have checks and balances in the body. You don't want to have the lungs fighting the heart and the heart fighting the liver. That's silly. We want to have everything working harmoniously together. And so that's what they decided they wanted to do. And they created these administrative agencies, which they very, aggressively gave both, legislative, executive, and judicial powers. If the idea of protecting liberty is to separate these powers, we have created whole institutions of government which have all these powers contained within it. And then they get to make the laws, although they're called rules, not laws, they're rules. They get to make the rules, and then those rules get to be both interpreted, administered, adjudicated, and enforced within the agencies. And where is the other branches of government in this? Well, once you set this up, and experts now are making these rules, and by the way, the experts themselves are not democratically accountable to anyone, which goes against this democratic constitution idea that they previously were touting, then the checks and balances turn around, they flip around. The only way to stop the administrative agencies from doing something is to go through the checks and balances, which means you got to get a majority or a supermajority in both houses of Congress. The president has to sign. If the president supports this and doesn't sign, then you got to have a supermajority to override the president. That's the only way a rule made by a unified non-checks and balances outfit, like an independent agency, can be reversed. And additionally, they insulated the independent agencies from even intervention or limited intervention by the president himself within the executive branch. And so they got this, in a sense, progressive fiefdom up and running, which they would then administer or influence by funding decisions in committees, and Congress would get their say. So and obviously Elizabeth is chomping at the bit to respond.
Well, I just feel like you've forgotten a major
progressive innovation, starting with James Bradley Thayer in his very famous Harvard Law Review article in 1893, we had the concept of deference invented. And first it was deference to the elected branches. Well, that might make some sense. But now, in recent years, it's been deference to the appointed branches as well. So you have Chevron deference, and you have our deference, and you have Seminole Rock deference. You got all kinds of deferences going on. But here's the real problem. It's the problem that I call double deference, and I'll I'll stop with this, with the double deference. Here's how double deference works, particularly with respect to the legislative branch, but also works with the administrative agencies. And that is, you all adopt this very hallowed view of deference, and you defer not only to the policy judgments of the other branches, but also, as Thayer urged, you defer to the other branch's definition of the scope of their own powers. You defer to that as well. And then you go across First Avenue and you First Street, and you ask the legislative branches whether what they're doing is constitutional or not, and what answer do they give? The answer they give, oh yeah, what we're doing is constitutional. You know why? Because the courts will uphold us. So on one side of the street, the courts are upholding the legislature because they're deferring to the legislator's judgment of constitutionality. On the other side of the street, Congress is saying what we're doing is constitution because the judges will say it's okay. Well, the judges are deferring to the legislature is deferring to the judges, and as a result of the problem of double deference, the Constitution and its constraints really never enters into the picture. So the progressives had a wonderful way of, in a sense, taking the judiciary out of the picture as well, and it goes all the way back to Harvard law professor James Bradley Thayer and his colleague, Harvard law professor Oliver Wendell Holmes Jr., who imported Thayer's views into his writings as a Supreme Court justice.
Okay, lots to talk about here, Elizabeth, but let's focus on Randy's claims about deference. So what is the counter argument? Hamilton talks about the judiciary as the least dangerous branch. The Supreme Court strikes down 2 federal laws between Marbury and Dred Scott. William Howard Taft, a great constitutionalist, nevertheless is deferential to federal laws and is on the other side of the Adkins case involving maximum hour laws, although he will enforce property rights at the local level. So is it your view that the bipartisan tradition of judicial deference championed by Holmes, Brandeis, Frankfurter, Byron White is consistent with the vision of the framers or not?
Yeah, I mean, I think that's going to be a big question, actually, going forward in the Supreme Court, especially depending on who fills the vacancy left by the passing of Justice Scalia, because this is something that has been bubbling up in the Roberts Court's opinion, as well as in academic circles. And I think we saw something of, it wasn't theorized in this way, but I do think it was a bit of a separation of powers themed point that Chief Justice Roberts made in the King v. Burwell case about the Affordable Care Act, this most recent one, where he talked about whether agency deference could be given or should be given to something that is of extreme national importance, whether or not Congress had to be clear in itself in the statute. And I think that thinking of the purpose of separation of powers is important when we talk about the administrative state, because the founders wrote into the Constitution government design where you had the legislative branch having the enumerated delegated authority from the people to legislate in these particular areas. And then you have the president who is required to faithfully execute those laws. And as our nation grew and our issues and our national problems grew in complexity, then I think it only makes sense that the subjects upon which Congress would legislate would grow and would become more complex, and the way in which the president would faithfully execute those laws would require different mechanisms for implementing those laws. That doesn't necessarily mean that the president is going above and beyond what Congress has said in its statutes. Obviously, that is incredibly important as the frame in which the president executes those laws. And so I think there's this quote from Hamilton that I think is really important when we talk about these things, because even though I am a progressive, I don't often agree with my progressive brethren that we can just sort of ignore the Constitution and do whatever we want. But at the same time, I think the genius of our founding fathers and our amending brothers and sisters who made the Constitution over time more equal, more just, and more free is that they wrote in a way that was adaptable. And this is what Alexander Hamilton reminded us of in Federalist number 34. And because I'm not Lin-Manuel Miranda, I will not do it in hip-hop style. I'm sorry. Or maybe you're welcome.
No, please.
And I'm cognizant of our time, but I think this is really important. He said, we must bear in mind that we are not to confine our view to the present period, but to look forward to remote futurity. Nothing, therefore, can be more fallacious than to infer the extent of any power, proper to be lodged in the national government from an estimate of its immediate necessities. There ought to be a capacity to provide for future exigencies as they may happen, and as these are illimitable in their nature, so it is impossible safely to limit that capacity. So they were looking toward the future. They were looking to have a constitution that would adapt to change, that would allow for change, that would allow for progress. And so I think that, when the judicial branch looks at the way that the administrative agencies are executing, implementing the law, then I think that that should be taken into account, as well as the more specific frame in which the case comes to the court.
Fascinating. Randy, I'm going to ask a parochial question for help. So my next book is a short biography of William Howard Taft, who turns out to have been a judicial president and a presidential chief justice. He was on the Sixth Circuit before he became president. His only ambition is to be chief. He reluctantly becomes president because Theodore Roosevelt and his wife make him, but he approaches the presidency like a judge. And everything that he does is in constitutional terms. And he will only recommend to Congress. He won't lobby because he thinks there are enumerated powers under the executive. He returns gifts because he thinks they violate the Foreign Emoluments Clause. And it's a fascinating vision for what a constitutionally minded president would act like. But it seems that Taft is a rebuke to your thesis, Randy, in this sense. His hero was Marshall. He thought the greatest American of all times was Marshall. He was a Hamiltonian. Although he resisted Theodore Roosevelt's populist efforts to overturn judicial opinions by majority votes and the Unitary executive and ran the election in 1912 in constitutionalist terms and defends property rights, he still has a broad conception of federal power, and he believes that the Constitution has to adapt to the times. He is not an originalist and does not embrace your vision. Is it fair to say that Taft is part of a Hamiltonian tradition that has a lot of adherence over American history? There's a contrary Jeffersonian tradition, which you're buying into, but both were present at the founding and have battled throughout American history, and therefore to claim that one trumps the other is ahistorical.
Well, there are two archetypes of the ways we, I think, view the Constitution that I talk about in the book. The book is identifying the two archetypes. One is, do we view we the people as a group who are entitled to rule according to the people's will, which is going to necessarily mean the will of the majority, because that's the only way groups have wills, is if they have them at all, is by a will of the majority. In which case, anything that gets away in the middle of the majority is problematic and presumptively suspect. Although most people will make exceptions, they have to be justified. Or are we the people individuals, each of whom are endowed by our Creator with certain unalienable rights, including life, liberty, and the pursuit of happiness. And the next sentence of the Declaration says, it is to secure these rights that governments are instituted among men, deriving their just powers from the consent of the governed. So first come rights, the rights of the individual, and then comes government as a means of securing rights. These are two archetypes. Not everyone is perfectly, not every historical figure you run into is a perfect exemplar of one archetype or the other. And after the progressive era got started in the late 19th century, there were many Republican progressives. Theodore Roosevelt, amongst the most famous progressive Republican, who ran against, after he was denied the Republican renomination, he ran against Taft on the Progressive Party platform. Herbert Hoover, you may forget, was in the Wilson administration and was a very, very prominent progressive before he became president. And for partisan reasons, the Democrats came less enamored with him, but he was in fact a progressive. Taft is a middle ground type figure, and there are a lot of middle ground figures in this era. None of us are so independent minded as to escape the gestalt of our day, and he was certainly one of those. And so I don't look to Taft as an exemplar of one or the other. In a way, he kind of combines both, whereas others were much more ardent advocates of one side or the other. So maybe it's nice for you, Jeff, who runs this center with such equanimity, to be focusing on Taft as the Chief Justice running the court with some degree of equanimity. Well, there's a certain justice in that.
Yes, it's an excellent homework assignment that I was given.
We look forward to the book, is basically what we're saying.
So do I. It's on a tight deadline. It will be out soon. The counter to you, Elizabeth, is given the battling forces of Jeffersonian and Hamiltonian constitutionalism, Randy's argument is at least plausible? And is it arguable that the court went too far in the
Can I quote you on that, by the way?
No, it's a question. Is it is Randy's argument at least plausible?
Yeah, okay.
Yes, you can quote it. I think I blurred this thing.
Randy's argument is at least plausible.
No, I
Jeff
said-
Rosen, National
said-
Constitution Center.
I said wonderful things about this book because it's excellent and it's more than plausible. But so the court, by essentially abdicating in economic cases during the New Deal, made a choice, and the pendulum may well be swinging back in the opposite direction. So might Randy, and recently, Jeremy's going to talk more about some recent decisions that are questioning the appointment of administrative law judges for violating the Appointments Clause. So if we see a revival of these separation of powers doctrines, the non-delegation doctrine and so forth, that have been dormant since the New Deal, you know, as a progressive textualist and originalist, are these decisions at least plausible?
Well, I think, you know, it is helpful to look at the purposes for which we've constituted the government. And, you know, I know we'll get into the more of the nitty-gritty later, but I think the progressive era is important in thinking about the administrative state. But I think more broadly, frankly, the Reconstruction Amendments are incredibly important. The Reconstruction Amendments were all about, in a lot of ways, answering the question that I think is posed by the 13th Amendment, which banned slavery, which is, what does it mean to be a free American? And the 14th Amendment and the 15th Amendment said that being free and equal, being an equal citizen in the United States has to do with getting equal treatment under the law, the ability to enjoy your liberty and make certain fundamental choices, enjoy the privileges or immunities of citizenship, something on which Randy and I agree, although on those precise contours, I'm sure we could have a very long debate. And the idea to have a say in your government and to vote. And I think this idea of equal citizenship that is a motivator of the Reconstruction Amendments finds its way even into these very, perhaps, dry administrative law questions. You know, when we're talking about restraining corporate corruption, whether that's through the CFPB, the Consumer Protection Agency, or whether that's through the SEC, Securities and Exchange Commission, trying to create laws that create a more fair playing field in the economic sector. I think it's important to think of these other parts of the Constitution, you know, that really breathe life into the structure that we're talking about.
That's such a important thing and such a large topic. Randy, you talk a lot about Reconstruction in your book. What's your counter to Elizabeth and scholars like Michael McConnell, who've argued that the Reconstruction framers in Section 5 of the 14th Amendment really wanted to empower Congress to enforce rights and did not mean to empower the courts?
Well, I think that's wrong. I mean, Elizabeth and I are, in fact, general agreement. We may not be in entire agreement about entirely what the original scope of the Privileges or Immunities Clause was, but we both agree it had a scope. It did mean stuff, and the record is, and there's a consensus amongst academics that this is true. And it's a long story as to why the Supreme Court refused in the McDonald case to recognize this, but partly it was they did not want to open up a Pandora's box of unenumerated rights that they couldn't control, where they thought they had controlled the Due Process Clause used for unenumerated rights. Anyway, we are in a basic agreement about this. The Reconstruction Amendments did alter our theory of federalism from what it originally had been, and did provide federal constraint on states so that states could not abuse the rights of their own citizens the way that it was constitutional for them to do prior to that. And there's absolutely no question, I think, that Section 1 was a judicial empowering provision, but the framers of the 14th Amendment did not trust the federal judiciary to do the job themselves, and they wanted an enumerated power put in the 14th Amendment to allow them to protect civil rights. Because remember, under the original meaning of the Constitution, enumerated powers were actually quite limited, and it was for that reason they needed an enumerated power to enforce the 13th Amendment and an enumerated power to enforce the 14th Amendment. Think of it this way. If the original meaning of the Commerce Power and the Necessary and Proper Clause means what progressives today tell us that it means at the framing, there would have been no need for the 13th Amendment, because Congress would already have had the power to abolish states. The economic activity of slavery in the states would certainly had a substantial effect on interstate commerce, and nobody, not the most radical abolitionists, thought that that was true of Congress's power. But so they gave themselves an enumerated power to do it, in addition to the power of courts. The last thing I think, since we're nearing the end of our time, I want to emphasize is you're all about to see one of those great reversals that we see periodically in history. The Chevron case was a decision of Justice Scalia, was one of Justice Scalia's famous decisions. Chevron deference to the administrative agencies during the Reagan administration, when the Reagan administration was doing EPA the way that progressive environmental groups didn't care for, they brought a lot of lawsuits. And Chevron deference was a doctrine that was somewhat invented to insulate the Republican administration from lawsuits in how they were going to be administering the EPA. I predict, and I don't think this is going to make me a soothsayer, we're going to have a lot more lawsuits challenging administrative agencies in the next few years that you guys are going to have to be dealing with, and I think there's going to be more of an intellectual consensus about that perhaps this deference has gone too far, and then we're going to have to be very interesting to see how people on the right are going to react, who have been very critical of deference up till now, and see whether they're going to have a new love affair with various forms of deference in order to protect the Trump administration from the myriad lawsuits that are being written, the complaints that are being written as we sit here today to stop regulations from being undone that we don't even know about yet.
That is an absolutely fair prediction, and indeed, in March 2016, Senator Mike Lee, our visiting scholar, introduced in the Senate a bill that would repeal Chevron deference and empower the courts, not agencies, to interpret all questions of law, including both statutes and regulations. It will indeed be interesting to see the fate of that bill. There's so much more to talk about, but as you suggested, Randy, the cardinal rule of the Constitution Center, like any good courtroom, is that panels end on time, and therefore, in a moment, I'll ask you to thank our incredible panelists, but first, I will introduce our superb next panel, and I have to say how meaningful the Constitution Center's partner with Jeremy Fogel and the Federal Judicial Center has been. This is the third of a series of judicial seminars we've done. 3 years ago, we did Madison's First Amendment. Last year, we just did a riveting series on Reconstruction and race and the Constitution that led to some of the most vivid and memorable private conversations among the judges that I've ever had the privilege of experiencing, and I know we're going to have similarly phenomenal discussions on and off the record today. Ladies and gentlemen, please join me in thanking Randy Barnett and Elizabeth Wydra and welcoming Jeremy Fogel.
Hi. Good luck. I look forward to hearing you.
Nice to see you.
Good job. Good job.
Where would you like?
Should I?
Doesn't matter.
I guess for the moderator, you might want to sit in the middle, or
No,
not. Okay.
I'm happy right
I'm
here.
just gonna do it.
So in the words of my great mentor Monty Python, now for something completely different. But I really would like to start by thanking the National Constitution Center and all of the wonderful people who work here, including Jeffrey Rosen, for a really great partnership. I think the last 2 times that we've done this have been terrific educational experiences for all of the judges who participated. And people still talk about them, talk about what happened and the conversations that we had, both in the public sessions and in the private sessions that we'll have later. And we also think it's really important to have these public sessions and engage with the community about these matters so they can see us judges as flesh and blood people who struggle with the same kinds of questions as everybody else. I'm joined for this next session by 2 very distinguished law professors. To my immediate left is Michelle Landis-Dauber from Stanford University. And to her left is Ilya Soman from George Mason University. And we're going to talk about how we got from the founding to where we are now, what the progress of the administrative regulatory state was from the beginning until the present. We heard a little bit about that actually in the first panel, but we're going to get into it in a little more depth. And I want to actually start by reading a sentence from a very fresh decision. It was issued by the Tenth Circuit Court of Appeals last week, so it's that recent. And they were called upon to determine whether administrative law judges at the SEC, the Securities Exchange Commission, were properly vested with the authority to make the decisions that had been made in this particular case. And the first couple sentences of the opinion read as follows. When the framers drafted the Appointments Clause of the United States Constitution in 1787, the notion of administrative law judges presiding at securities law enforcement proceedings could not have been contemplated. Nor could an executive branch made up of more than 4 million people, most of them employees. So this was the context in which the court was operating, and they actually decided by 2-to-1 decision that the administrative law judges employed by the SEC do not have the power to make the type of decision that was made in that particular case. That's created a split between circuits, and so the issue almost certainly will be before the Supreme Court sometime soon. So this is really very much something that's front and center, and really without commenting on whether the change in administration is a good thing or a bad thing, I think it's clear that it is going to make this issue more salient, more important in the coming months and years because of the conflicting philosophies between the administrative state that we've all lived with and grown up with and some of the things that have been said both by the incoming administration and by Congress. So to elaborate a little bit on the historical context, I want to start by asking Professor Dauber a question. When we were talking about this in preparing for today, there's certainly the way I learned it in my study of American history was that we really had kind of small government. I always think of Calvin Coolidge and his predecessors, and that what really created the administrative state that we have today was the New Deal. It was the Great Depression and the necessity of having to deal with the immediate suffering of millions of people. Well, it turns out that that's just not right. And we already heard from Professor Barnett and from Ms. Wydra that there were developments well before that. But this is something that Professor Dauber has studied in some detail. So give us your account, really, in a short form of how we got from the founding to the era in which the administrative state is a basic part of our structure.
Great.
Yeah.
And first of all, I'd just like to thank you, Judge Vogel, and also thank the Constitution Center for inviting me. It's really an honor to be here. So in the case of the welfare state, our understanding of the New Deal as being, really the kind of beginning of the federal government's engagement in that kind of activity that is the kind of, massive relief efforts and so forth. One of the most surprising findings in my research is actually the long history of federal redistribution for people who were needy, particularly following events that we now think of as disasters or catastrophes, that is fires, floods, hurricanes, earthquakes, but also other kinds of more man-made events, wars. The War of 1812 actually provoked a very, very robust relief project, including the appointment of Federal Relief Commissioner and the development of an administrative bureaucracy for taking applications and investigating claims and taking evidence and taking testimony and then distributing federal money. And so these kinds of redistributive efforts really began in the late 18th century, and they gathered steam more or less uninterrupted, with Congress feeling really constrained by the force of its previous precedents, which is another interesting finding in this research, actually, because we think of the legislature and a court as quite different, but there was a lot of confusion in the early Congresses about whether they were supposed to operate more like a court in adjudicating claims or more like a legislature. And so by the time of the Civil War, This was a really well-established pattern, and then it really escalated in the period of the Civil War. So, and then after it, this kind of practice of redistributive bureaucracy and of distributing money and other kinds of relief in the aftermath of disasters, so that when people were needy, really snowballed. And so during the period that we think of now as the most constrained, the so-called Lochner era, this was really kind of the golden age of the development of, the kind of redistributive apparatus. And there was a constitutional theory that came along with this, which was the theory of the expansive general welfare clause. Now we'd call it the spending clause, but it was called the general welfare power or the general welfare clause. The ability of Congress to tax and spend in the general welfare was an incredibly robust power. It still is an incredibly robust power. And it was seen as a way that Congress could really engage in this kind of activity, develop this kind of administrative capacity, redistribute from the better off to the less well off, and really do it in a way that was free almost entirely of judicial review. Because the courts took the position, including the Supreme Court during this period, that what was the general welfare really was for Congress to determine. Whether to spend in the general welfare was up to Congress, and the content of what was in the general welfare really was for Congress to determine. And this was an idea that had tremendous support across all sections of the country, across all political parties. Even James Madison, I think we're all familiar with the idea that there was this dispute between Hamilton and Madison, and Madison was in favor of only spending in enumerated powers. The great thing from the perspective of the New Deal about the general welfare power was that it was the power to spend for unenumerated goals, and everybody, including James Madison, agreed that you could do this. And in fact, he personally was involved in distributing disaster relief on numerous occasions.
So what I'm hearing here is that what happened in the Progressive era and in the New Deal was really a matter of degree rather than of kind. In other words, there had been, in your view, a recognition that Congress had the power to create these administrative agencies, these administrative apparatuses to distribute value to the people under its general welfare power, and that the large expansion, which indisputably occurred in the 20th century, was simply building on that foundation that was already there.
Absolutely. Well, yes. There had been other large expansions. For example, the Freedmen's Bureau was an earlier large expansion of this power or of this, sort of scope. But yes, it was a difference of degree rather than type, although, I suppose at some point the degree is so much larger that you may argue that you've now crossed the threshold into a type.
Okay. So, Professor Soman, what do you think about that? Your perspective, as I understand it, is a sort of libertarian perspective, similar to what we heard from Professor Barnett earlier. How do you interpret this?
So I partly agree, but partly differ. Where I agree is I don't think there was a single moment, whether in the 1930s or any other time, where before everything was completely limited and after it wasn't. Clearly, there was a more gradual process. However, I think there are a couple ways in which the account we just heard needs to be supplemented. First, on the spending side, it was not the case that everybody agreed that the general welfare was just whatever Congress might think that it is. Throughout the 19th century, there was actually great dispute over this. James Madison, Thomas Jefferson, Grover Cleveland, a number of other presidents all vetoed or opposed on constitutional grounds various kinds of spending for local projects, including in some cases disaster relief, because they said this is not really for the general welfare. Now, it is true that even some of these people may have violated their own principles in emergency situations and the like, wars, natural disasters, and so forth. But if we say that everything that was ever done in the midst of a huge disaster or an emergency is constitutional, we wouldn't have a constitution left left. There's not a single limitation on government power of almost any kind that's in the Constitution that hasn't been violated at some point during an emergency. People used to say the Third Amendment is an exception to that, the one that bans quartering of troops in people's houses. Turns out that too was violated during World War II and on a pretty substantial scale, actually. Doesn't mean it isn't a real limit in the Constitution or that the Congress or other agencies of government can do whatever they want. The second way in which I think I would supplement the account that we just heard is that the heart of the modern administrative state is not just spending money or redistribution, it's regulatory power. That's what most administrative bureaucracies that we have now actually do. And on that, I think the history is somewhat different. To give you just one example, as late as 1920, the dominant view was that people who wanted the federal government to have the power to prohibit alcohol possession and distribution, that you needed to pass a constitutional amendment to do that. You couldn't just say, well, you know, alcohol has an effect on interstate commerce, and therefore the Congress already has this power. Some people did say that, but that was very much in a minority. So they had to pass a constitutional amendment. And there you really do have a revolution during the New Deal where both Congress and the President and ultimately the Supreme Court essentially come to say that there are few, if any, remaining limits on federal regulatory authority, whereas previously I think that was not the dominant view at all, although again, certainly there were some deviations, particularly in emergency situations. Don't want to say that somehow things were completely pristine. So obviously there's a bigger question about whether the shift that happened in the early to mid 20th century was a good thing. I think overall it probably wasn't, though there were some ways in which it might have been unavoidable. But I do think there is a big shift, particularly on the regulatory side, but even on the spending side, we moved from a period when it was at the very least very contestable what the general welfare meant to one where Congress is seen as having nearly total discretion over this subject.
You know, let me see if I can reframe this a little bit. The Freedmen's Bureau, which Professor Dauber brought up, we talked about that a little bit last year in our Reconstruction program. So it's clearly a welfare program, if you want to use that terminology. Would the folks who staff that in the various states have ever thought that their power included the ability to make the kinds of regulations that today's agencies do, or that their regulatory power would be subject to deference? Or is that something they just never would have thought of?
Are you asking me?
Yeah, either of you. Yeah.
Well, I think that the Freedmen's Bureau actually is a great example because they had tremendous power, really both on the spending side and to some extent regulatory power within the local context in which they operated. But it was one of the things about having what I call a sort of a disaster relief welfare state is that there is both a limitation and an opportunity there. There's a limitation in the sense that these things that the government redistributes for tend to be seen as short-term needs, seen as things that could be determined by Congress. We pay a lot of attention to how it is that people came to be in need, but there's also an opportunity, which is that once you understand that this is, with all due respect, an extremely well-established tradition that is basically uncontroversial and with very, very limited exceptions, Grover Cleveland being one in 1887, and he paid a price for that, one drought relief veto, with very, very limited exceptions, extremely uncontroversial. It's hard to overstate how uncontroversial disaster relief really is. Once you understand that, you can see why the New Dealers picked that as a course to follow.
But if I understand the critique that Professor Soman made, and I think that we were hearing from Professor Barnett earlier, disaster relief is one thing. It's to say we have to help people, we have to get relief to them, we need an administrative apparatus to do that. It's quite another thing to have agencies like the EPA or the FCC or the SEC, which become entities in themselves that I think the critique was they are judge, legislator, and executive all in one without the constitutional transparency. Is that the heart of where you're going?
It's part of it.
Yeah. What else?
So, as I said before, regulatory authority is much more sweeping than merely the ability to spend money in various contexts. And I also think, as I said earlier, that things that are done in emergency situations or what are viewed as emergency situations should not be viewed as sort of these broad precedents that you can do it all the time. And similarly with a disaster relief situation, not only is it an emergency situation, but it's also, for totally understandable reasons, extremely appealing politically. You have these people who are suffering greatly through no fault of their own, so it's understandable that politicians will often feel the need to set aside their own constitutional principles that they might otherwise uphold in order to spend in these situations. It is just one of many situations where they do things that are politically expedient rather than what might be constitutionally right, and I get that. No constitutional rule is going to be 100% rock solid in the face of all temptations, and I think we can live with that so long as we don't then say, well, if we do it here, that means we can do it everywhere. This stuff is not like virginity. It's not a situation where once you lose it, it's gone forever. Even if you lose it in some instances, you can still maintain a certain level of propriety in others.
Okay, so you would, I take it from what you've said, you would roll back the extent of regulatory power that these agencies have. I mean, from a constitutional perspective, they do more than they should be doing.
Yes, I'm not saying,
Yeah.
I would say that the courts, all of you here, should immediately roll things back to what it was in 1920 or what. I don't think that's realistic. There are issues of established precedents, reliance interests, and the like, but at least as a textual and original matter, I do think the power that exists today goes far beyond what was understood and intended, not just at the founding, but even as of 1920, as I mentioned in the case of prohibition. What we do about it today is a very hard question, and perhaps we'll get to it later in discussion.
Oh no, we're definitely going to talk about that. But I want to try to understand the history as fully as we can in the limited time that we have. So, Professor Dauber, let me ask you the same question. So, there's sort of the idea you need this administrative apparatus to deliver services to the people. Do we need the kind of administrative apparatus that we have? Is there a constitutional foundation for Chevron deference, our deference, Skidmore deference? I mean, is that all stuff that got made up out of necessity, or does it grow out of historical roots? And if so, what are the historical roots?
Well, I think that absolutely there is an issue of necessity. As the constitutional sort of framework elaborated around the need to, as you said, deliver relief, or I do want to make a distinction, however, between the parts of this that I study, which really have to do with the general welfare clause and the general welfare power and redistribution. And I do think that it is a reasonable distinction to make between the regulatory apparatus. And in fact, one of the things that you can see happening throughout the 19th century is a choice being made, and this becomes particularly acute during the New Deal, as the Supreme Court starts to shut the door on the Commerce Clause, by Congress and the executive to start to expand the welfare power.
So this is in the early 30s?
Even in the 1920s, but again in the 1930s. So the history of disaster relief, was very attractive to the New Deal because they looked at it and they saw, oh look, the spending power, right? Here's a sort of a way we can get done what we want to do. And yes, it doesn't allow us to do all the regulation we would like to do, but it allows us to do quite a bit. And the court has taken a very hands-off approach to this. So if you're a New Dealer in the early 1930s and you're looking for a constitutional basis for the thing you want to do, which is help people and prevent them from starving to death or freezing to death, disaster relief looks pretty attractive, right? It seems like a real target of opportunity because the court has said, into this thicket, as Edward Corwin said, we shall not thrust our sickle. This is up to Congress, right? And so that provided an opportunity, and you can see programs start to migrate as the New Dealers realize that they have this sort of unfettered opportunity to develop the things they wanted to do through the spending power. There are limits to the regulation, however, that the government can do, as I think we saw start to play out recently under that clause, as opposed to under the more robust commerce power.
Right. So there was the in the ACA case, I think
Yes.
Ms. Weider was talking about that, the King versus Burwell, that there was an invitation. In fact, the court could have decided the case based on Chevron deference if they wanted to, and they explicitly chose not to do that. Yeah. So, you know, where are we? I guess I want to ask you both as law professors who've thought about this. You know, even if there is this long historical tradition of helping people in disasters and so on, and you know, obviously the president and Congress can't go out and deliver the disaster relief. You need an apparatus to do it. That, as I think we've heard from both of you, evolves into a pretty complex regulatory structure. Is that constitutionally sustainable? And what's the path forward?
So I think there are serious problems with this from a constitutional point of view. I think there are also serious practical problems as well. One practical problem is that the regulatory state is so enormously large and controls so much of our lives that there's very little meaningful democratic accountability to a lot of it. I've written an entire book called Democracy and Political Ignorance, where I discuss how most of the public only has a very modest understanding at best of what's going on in government for perfectly understandable reasons. They don't want to spend their time studying the details of administration. So as a result, most of what the federal government does, they have very little understanding or control over. Even Congress or the president often can only do so much in overseeing this vast regulatory state. And there's also a trade-off here in that if you try to make the regulatory state sort of independent and expert and controlled by administrators, there's very little accountability. If, on the other hand, you take a unitary executive view and you say, well, the president should control it all, then you have this enormous concentration of power in the hands of a single person, far beyond anything envisioned by the founders or even by people 100 years ago, and that's dangerous and menacing as well. If you didn't think it was menacing under the last administration, many people who didn't worry about it then are likely about to worry about it after January 20th, and vice versa. Probably some people who don't mind the incoming president having that power certainly very much did mind under the previous one. So there is a danger of lack of democratic accountability. There's also a danger of over-concentration of power, and there are serious practical problems with the fact that we have a highly diverse nation of 300 million people, yet we have a regulatory bureaucracy trying to impose one-size-fits-all solutions to all kinds of things, including what kind of toilet flow you can have in your toilet, what kind of light bulbs you can hang up in your house, and on and on and on and on. So a lot of times people say we got to have this in the the modern world where things are complex, and I recognize it's probably not going to be feasible to fully restore the original meaning of the Constitution here, but there are also serious practical problems with the nearly unconstrained regulatory state we've created, and I think it should be possible to pare that back, even if we can't.
The court in need. That's just not the case. There really was not even the strictest of strict constructionists, Calhoun and Breckinridge and Madison and Jefferson and Tucker, really felt that a state that lacked the power to come to the aid of people was not really a state worth having. When people are in need, and you use the phrase through no fault of their own, which is a phrase that comes up over and over again in the historical record and was a phrase that Roosevelt liked to use, and also Lyndon Johnson, when people are in need through no fault of their own, I think there's tremendous agreement that the Constitution is capacious enough to allow that and to allow the administrative bureaucracy essential to make that happen. I think the innovation that occurred during the New Deal and the reason that we understand the New Deal to have been this watershed moment is because the thing that could count as being through no fault of your own changed. So previously, you might have had to have had, some kind of a flood or a natural disaster or be attacked by, the native population. And during the New Deal, the real innovation was that being unemployed, that is being a victim of an economic breakdown, that had gone unregulated by the government, or for whatever reason, losing your job, having your factory move away, no longer making shoes in Massachusetts, for whatever reason, that could become like being hit by a flood or a fire or an earthquake or an attack of some kind. That was the real innovation, and that was the change in kind or in scope or in scale. That is not going to change, I don't think, although never say never given recent events.
Well, let me ask you, let me follow up in two different dimensions with regard to this, because I think I can speak for every judge here, including myself, that if you get a sort of a very tough environmental law case, a water law case, or you get a patent case that has a very difficult technology, or any number of other things one could think of, the level of expertise that's necessary to understand what's at stake in the case is extremely high. You have lots of expert testimony, and you're kind of pouring through records to figure out, well, what is this? So is it realistic to think that agencies could figure those things out without a certain degree of deference? In other words, would every agency's assessment of the appropriate application of the technology be subject to de novo review by a court? Is that a realistic standard? Professor Solomon, what do you think?
I think it's certainly realistic to say that there should be much more de novo review than there is now, because technical expertise is not the only thing at stake here. There's also the question of incentives to overextend your power, which constantly exist in administrations of both parties. And there's the fact that often the claims of expertise are themselves greatly overstated. The agency certainly knows certain technical facts on average better than judges do, or law professors, anybody else. On the other hand, when you have a single center regulating a vast, diverse nation, there's a tremendous amount of ignorance that even the most expert agencies have about what's actually going on the ground. This is the kind of thing that afflicted central planning in the Soviet Union and other communist nations and helped cause them to collapse. But we have it to a smaller degree in our country, where we have a vast regulatory empire controlled by the federal government that is actually already much larger than many than the economies of many total nation states. So while the bureaucrats or the experts, they do know a lot about technical scientific facts and the like, often they don't really have more than a superficial understanding of the needs of the people on the ground, those actually affected by the regulation. And so if we could pare back the scope of that regulation and the scope of that discretion, we might actually be able to leave more authority to individuals who actually know more about their situations, or in some cases to state and local governments who also have problems of their own, of course, but don't suffer quite the same sorts of information problems as centralized regulators do in Washington. So I think the problem of expertise in many cases actually counsels in favor of less deference rather than more, and in favor of rethinking whether we really want the enormous scope of federal power that has arisen over the last 70 or 80 years. Again, not saying courts or anybody can immediately say, we'll just roll everything back to what it was before, but it's not an either-or proposition. There are many ways we can limit
So let me
power.
just push you a little bit. I mean, it's not an either-or proposition, but how do you get your arms around it? In other words, I can't imagine, and I'm going to ask you about politics in a minute, but I can't imagine Congress legislating things at that level of detail. It's one of the questions actually that we got is how can we expect Congress to do that? And putting aside political gridlock and things like that, and just sort of thinking about it on the level of expertise, or how do you, a judge is reviewing a regulation who doesn't have expertise. I mean, where is the appropriate line of deference to expertise? I mean, we live in a very, very complex and technical world. So you can say we defer too much, and I think a lot of people would agree with you, and some would disagree. But how do you frame it so that the inquiry is consistent? So it isn't just, well, I don't like that opinion, so I'm going to find it unreasonable.
So I would begin by trying to limit the scope of the problem. I think courts, the Supreme Court, can overrule at least some of the most extreme precedents, expanding federal power like Gonzalez versus Raich, mentioned in the previous panel. Congress can do something which it may be considering doing, like passing the REINS Act, which would at least require some of the more expansive regulations to go before Congress first to be approved. In the area of the spending clause, I think, as I've outlined actually in a little piece for the National Constitution Center, courts can at least strike down some of the more extremely local projects which are clearly not in the original meaning of the general welfare, and there's a large number of other intermediate steps like this that can be taken, including cutting back deference at the margin. It would eat up the entire rest of the time to go through them all, but there's a lot you can do without saying, well, now we're going to bring back what FDR called the horse and buggy constitution. I don't want to bring back horses and buggies, but I also think the current situation is unacceptable in many ways and can be improved at the margin.
Okay, Professor Dower?
Well, I'm not sure why you think an Article 3 judge is a better assessor of what is, I think you said, sort of the will of the people, or closer to what the people want, than the administrative agency that's engaged in notice and comment rulemaking, for example, and has technical expertise. I mean, I'm not sure why we would prefer the Article 3 judge's review to the agency. And in terms of the general welfare or the spending power thing that you just mentioned, I just want to make it clear, the Supreme Court has never, in its entire history, in the whole history of this country, never struck down any act of Congress because it disagreed with Congress's view of what was in the general welfare. Never. The closest it ever got to that was the Agricultural Adjustment Act, which it could have struck down on that basis, but did not. Instead relying on a convoluted, 10th Amendment sort of very problematic argument that no one thought held together at the time. So, if you want to start recommending that judges are going to start questioning the general welfare, what Congress thinks, I think that the whole question of deference either to Congress or to agencies really raises the question of why are the courts in a better position to judge? And when the court has taken a look at this question, it's mostly decided that it isn't.
So let me add one more ingredient to the stew. Politics, right? So, I mean, I think anybody who's ever seen an administrative hearing process or lobbied in Congress for legislation realizes that things don't just happen. It's not like people go into a room and say, well, what would be the best thing to do here? And you arrive at it through some sort of Socratic process. I mean, there's a tremendous amount of special interest influence being brought to bear on the development of any regulation, any legislation. What do we do about that, or is there anything to be done about that? Is that just the nature of democracy? And then how does that cut in terms of what we've been talking about?
So in some ways, obviously, special interest pressure is part of the nature of democracy. That's unavoidable. That's one of the reasons why we might want to have constitutional limits on government power to constrain that to some degree. It's true, it might constrain the power to help people. On the other hand, the power to help is also a power to harm, and there are many ways in which the vast expansion of regulatory authority has in fact caused great harm. You just mentioned the Agricultural Adjustment Act. What did that act actually do? What it did is it artificially limited the production of agricultural goods, in other words, food, in the midst of a Great Depression where millions of people were already suffering from malnutrition, having trouble making ends meet, and so forth. For various somewhat crackpot economic theory reasons, some regulators at the time and others thought that this was actually a good idea and would somehow fix the Depression, but almost all economists today, and many at the time, would recognize that that's not the case. And this is just one of many examples where the expansion of authority of this kind has caused great harm, as well as, I concede, in some instances, helping people too. And so we want to have some constitutional limits, not because judges are better at divining the will of the people than regulators or politicians are, but because judges, I hope, are better at divining the meaning of legal terms, including, yes, general welfare and other provisions in the Constitution.
I'm sorry, could you repeat the question?
No, I was just talking about what, if we're saying there's too much non-transparent regulation and not enough democracy, what about the reality of democracy? That the legislative and regulatory processes are, there's a whole street in D.C. which is just full of people who do nothing but that, right?
Yeah, I definitely think that the problem of special interests and lobbyists and it is an interesting one, and it actually has a history even in the context in which I research. So one of the Supreme Court precedents, for example, that was very, very well known in the late 19th and early 20th century is a series of cases called the sugar bounty cases that I discuss in my book. One of the precedents for why Congress can spend in the general welfare has to do with the Mckinley Tariff, which we may all become experts on tariffs soon, but the Mckinley Tariff, which and the power of the sugar trust. So, if you think of the power of the oil and gas industry today, the sugar industry actually was one of the most powerful industries in the country at this time, and they really dominated federal politics, and they were quite corrupt. Lots and lots of corruption and lots of sort of hand in the till politics, and they extracted a bounty as part of the Mckinley Tariff to sugar growers. And the Supreme Court, this was just seen as just absolute corruption. It was the most corrupt thing Congress ever did, paying these people a bounty. It was evidence of why you should rein in the general welfare. I'm sure that if you studied it, you would say, aha, this is exactly the kind of thing, the reason that we need the judges to step in. And in fact, the Supreme Court took a look at it. This would have been a great case, in fact, to start to define the general welfare, because it was just pure graft, basically. And the court said, we're not going to get into the business of second-guessing the democratic process. Really, the general welfare is something that Congress has to determine, and if the people feel that Congress has gotten it wrong, the remedy's at the ballot box, not at the court. And that precedent is still good today, although people aren't familiar with it anymore. And I think that has to be basically right, at least in the area of spending. Otherwise, can you imagine the courts reviewing every single appropriations determination? I don't think that's very practical.
I think they got it wrong. Just like the court in that area got a lot of things wrong. I don't see why general welfare is any more difficult to interpret than equal protection or due process or liberty or property or any number of other words that all of you interpret all the time in your jobs. Obviously, there are going to be some borderline cases. You may be in a borderline case. You should defer. That's a reasonable position. That doesn't mean that sort of blatant, very local spending or blatant graft, as you called it in this case, that should be allowed to fly, just as with pretty much any other provision of the Constitution, whether structural or rights-based. There are going to be some tough borderline cases, and people can reasonably argue about maybe you should defer to Congress or to an agency or to somebody else in the tough borderline cases. But at the same time, you can do that while still picking off the low-hanging fruit. And there's a long history about the meaning of general welfare and what it was originally understood to be and so forth. So it's not just that judges would be reliant on just their own intuition of what's in the general welfare or on what their political party today might think it is.
So let me close this session with one question. I'm going to attribute it to my friend and law school classmate, Judge Wake from Arizona. And he said that a lot of times Congress is tempted to simply not decide the tough questions of policy and say, well, let's let the agencies figure it out, and let's let the courts figure it out, and then they'll get blamed if people don't like the outcome. So you leave things vague on purpose. That's actually part of the congressional intent, whether they're explicit about that or not. Does that ring true? And what relevance would that have to this whole conversation?
I think that absolutely makes sense, particularly in the area of agency delegation. I think maybe a little bit less sense in the area of the courts. To say, well, we'll let the courts, sort this out. I think to say we'll let the agency solve these sort of problems at the micro level because we're not equipped, just as the courts aren't equipped to do some things, and Congress will.
But there's also, we're not equipped because we don't have the expertise, but it's also, we don't want to decide it because it would put us in an uncomfortable political position. So there's almost an intentional deference to the administrative agency to avoid making a tough.
To avoid political accountability.
Yeah. Does that seem right? I mean, it's a fact on the ground, and does it matter?
I mean, I'm sure it does happen sometimes.
Yeah, I agree.
Yeah.
I think it's hard to measure the incidence of it, but,
Yeah.
but it certainly does occur.
Yeah. Okay. Well, we are at our appointed time, and I want to thank my colleagues for a very thoughtful discussion, and we're going to continue it in. We're going to continue it, and we're going to take a 15-minute break, and then we're going to bring up a couple of very experienced federal judges and get their point of view. Okay. 15-minute break. Great job.
Thanks.
Thanks.
We're back, and we're going to get started again. Everyone can find a seat. We're going to pick up on where we were in the first two sessions and look at it from the standpoint of judges. And we have two terrific judges to help us in this conversation. I'm proud to call both of them my friends, and they both have done a tremendous amount for the judiciary, for judicial education, and this is just the latest example. Next to me is Judge Kent Jordan from the Third Circuit Court of Appeals, right here. He's based in Wilmington, Delaware. And to his left is Judge Willie Fletcher from the Ninth Circuit. He sits in San Francisco. And both Judge Jordan and Judge Fletcher have been circuit judges for long enough to have seen a lot of this. And the judges in the room will tell you that these kinds of issues that we've been discussing are very much the bread and butter of what we have to deal with, both at the trial and the appellate level. I want to start with a very general question to both of you, and then we can get into some of the details. But from your experience, what are the most significant constitutional questions that are raised by the administrative state? Ken?
Well, we heard them touched on this morning. When you say the most significant, to me, they are structural questions that are raised by administrative agencies exercising what is in effect the powers of all three branches of government. The notion that you could have, and you can pick an agency, but the EPA is one that gets picked on a lot, that it can promulgate a rule which has the force of law. It can send out an inspector to investigate and choose to enforce, and then it can adjudicate that investigative decision to, in effect, prosecute is for a lot of people a profoundly troubling thing. Is it right to have an agency which is known as an independent agency doing all of those things at once? That's not a minor issue, and the book that Professor Barnett wrote and that he talked about today, and a recent book by Professor Philip Hamburger and others have very explicitly raised the question, how can that be consistent with our constitutional structure? You can say that's good government, and you can say it's pragmatically a helpful thing, but can you say it's consistent with the structural limitations that were embedded in the Constitution? And that's a serious question. Query what do you do about it? That's a different question, but the deep question, the profound question is how do we end up in a situation where something that the founders clearly didn't want to have happen, that is, have those powers all exercised in one set of hands, is really happening. And you can have people say it's not happening, but I think the Chief Justice's dissent in Arlington City makes the point that people will be forgiven for thinking that what's happening is in fact legislative rules and laws coming out of the executive branch and being enforced and adjudicated there too.
Willie?
Well, I think the central question is the modern federal administrative state constitutional? Another way of saying that is the modern industrialized Western state constitutional? I think it is inescapable that in current circumstances that there be a fair amount of regulation of our economy. To argue that it's inconsistent with the Constitution reminds me of the famous crack usually applied to economists. Well, it works in practice, but does it work in theory? We've had over 100 years of experience with the administrative regulatory state. there's really not very much fight about the government, even the federal government, giving out money. To the degree that we fight about it, it's maybe we don't think the recipients deserve it, or maybe it's being used to control because here's the money, it's conditional. But by and large, we don't fight about that. What we fight about is the regulatory state. And the federal regulatory state, if we want a beginning point, probably is 1887 with the Interstate Commerce Act. We then have the Federal Trade Commission. We then have an explosion of the regulatory state, of course, in the New Deal. One of the ways of explaining many of the decisions of Chief Justice Charles Evans Hughes was his desire to bring the administrative state under control, not just hostility to regulation. And by the time we get to the by the time we get to the end of the court crisis, we really have achieved a fair degree of consensus as to how the administrative state ought to be run. The ABA, very conservative, very anti-regulation in those days, had a proposed statute, the so-called Walter Logan bill, which would have greatly hampered most regulation. That didn't pass. There was a commission appointed by Roosevelt that was much more moderate, that produces a set of recommendations that get put on hold until after the war, and then we get the Administrative Procedure Act in 1946. The Administrative Procedure Act has been modified, expanded, changed in various ways to produce what we now have as the basic governing structure for administrative agencies, but we've been doing this now for over 100 years. And the truth is, if you look at it in gross, instead of objecting to a light bulb rule or this rule or that rule, if you look at it in general, our federal administrative agencies are doing a pretty good job. So to come back to the crack, it works in practice but not in theory. Those who would throw it out, sometimes it looks to me as though they're saying, well, here's the theory, and I don't care if the theory works, which suggests to me that there's something much deeper at issue than just constitutional theory, but rather they just don't like regulation. They don't like regulation by the federal government. They don't like regulation to the degree that we are now being regulated. But if the question is the modern administrative regulatory state as exemplified by the federal government, is that constitutional? I think the answer to that is yes, and it's yes if we do it in the most elemental terms. Is the Supreme Court prepared to strike it down? And the answer to that is no.
Kent?
Well, definitionally, if the Supreme Court says it's constitutional, right, then we all consistent in, ever since the Interstate Commerce Commission was set up back in the 1880s, the assertion has always been, this is necessary. We have to do this. And indeed, today the assertion is it would be impossible to function. Would not say it happened. Many of which have come into really the questions which are frustratingly more on the margins, because there's not much I can influence. But the question, for example, of deference, just allowing interesting and
that.
Set them up in the regime. One is the one you mentioned, which is it's easy for legislators not to take responsibility and to own the political consequences of making certain tough decisions, to be deliberately obtuse. Now you couldn't expect Congress, right, to legislate in the kind of detail that an administrative agency can when it brings to bear certain expertise and has to look at the finely grained stuff. but does Congress really have to be ambiguous about as much as it's ambiguous about, or is it just dodging its responsibility? That's one question. And the second question, and this is raised by something called our deference, not O-U-R, but A-U-E-R, I think is the name of the case, where the Supreme Court said, not only do you courts defer to agency review of the agency's own statutory authority, you defer to the agency's interpretation of its own regulations. And that, I have seen it happen where I pretty strongly suspect, can't prove it, that some of what's going on when you get ambiguous agency regulation is giving themselves maximum flexibility to move and shake and do what they want in any individual case. That lack of notice, that lack of giving people clear prospective rules is in part a function of this deference regime, which leaves the federal courts out of what I think both the Constitution and the Administrative Procedure Act foresaw for the courts, which is to say what the law is.
So I'm trying to think about this as a judge, and I'm thinking, well, now I don't have deference anymore. These deference doctrines are not appropriate under the constitutional framework, and so I'm getting these administrative law cases. Mm-hmm. And I essentially am required now to engage in plenary review of those records without any expertise. How do I do that? I mean, what is that? First of all, is that right? And well, secondly,
maybe I've overstated my case, because I wouldn't say no deference.
Yeah.
Chevron deference is a different thing. Before Chevron, before the Administrative Procedures Act, there was Skidmore deference, right? Judge Fletcher pointed out that the New Deal court was struggling with how do we, and they had been, how do courts review these things in a sensible way? And one of the ways that they had developed was this idea that where there is persuasive force and where there's clearly an expertise component, a technical component, that's where it makes sense to defer. And I think judges, sound thinkers, always would say, look, if I don't have the capacity to review that in a meaningful way, I shouldn't pretend I do.
And how do you know that? Because some of us judges think we know a lot about a lot of things.
Well, I'll give you I think a good example. Sometimes we are told that we should defer to what the Board of Immigration Appeals thinks is an aggravated felony. Well, why would I think that an immigration judge has a better handle on how to interpret a congressional statute bearing on criminal law than I do?
I think Judge Fletcher would agree with you on this point.
Yeah, well, so maybe I'm a little aggressive in my own view of my capacity, but I think that's an example of deference run amok.
So we need to develop the common law to define deference more sensibly?
Yeah, precisely. I think a Skidmore deference regime is vastly preferable to a Chevron deference regime, and we can get into Chevron a little more, but I don't want to be filibustering Judge Fletcher's opportunity.
He's ready to go. So.
Well, I'm going to revert to, for just a moment, my teaching style. I used to teach administrative law. Let me make sure we all understand the three kinds of deference: Chevron, Skidmore, our. Chevron deference, the agency, through some formal process, usually rulemaking, notice and comment rulemaking, but sometimes other things, but some deliberative and formal process tells us what it thinks the statute means when the statutory terms are ambiguous. And we are required to defer to, we as judges are required to defer to that, and the agency gets to tell us what that law means. That's Chevron deference. Skidmore deference is the agency in its internal manuals or less formal documents, less formal propositions, has a practice or tells us what it thinks the law means, if it's not formally determined by the agency, we get to consider that for its persuasive value only. We can ignore it. Our deference, as just explained, is the agency writes a regulation, and the court, in the case called Auer, A-U-E-R, as Judge Jordan told us, we're required to defer to that too. Let me invoke Justice Scalia. Professor Barnett misspoke. He said that Scalia wrote Chevron. He did not. He was not on the court at the time. Stevens wrote it for a unanimous court. There's no fight about Chevron at the time, and I think there's no fight about Chevron now on the court. Justice Scalia, however, hated our deference. Justice Scalia liked Chevron deference. He wrote a very nice piece in the Duke Law Journal about 3 years after it came down, justifying it not only in practice but also in theory. But he didn't like our deference, and I think he's right. You should not allow an entity that wrote the law to interpret the law, and that's what our deference allows. Chevron deference does not do that. That is to say, Chevron deference tells us that Congress has told us what the big structure of the statute is and has given it to the agency to fill in the details. But that's Chevron deference. We defer to the law as written by Congress, as interpreted by the agency.
And then the agency has to do the notice and comment rulemaking to do it, correct?
And it has to do it in a very formal way. Now, we talked about in the previous session the difficulties of lobbying in front of the agencies and pressure groups and so on. Compare it to the lawmaking of the Congress. The lawmaking or the rulemaking by the agencies is highly regulated by comparison to what Congress does, absolutely transparent and pure as the driven snow by comparison to what Congress does. Now, you might complain that it's unreviewable. Well, yeah, so is an act of Congress unreviewable, or it's unreviewable by judges. That doesn't mean you can't change it. It means when the new administration comes in, we have a new Department of Agriculture, we have a new head of the Forest Service, all of a sudden the forest plan gets changed. We as judges have limited power to change that. We have some, the hard look doctrine and so on, but to say that the regulations are unreviewable, there's an unstated premise. Do we mean unreviewable by us, the judges? Well, maybe they should be largely unreviewable by the judges.
You mean for content, not for if they exceed constitutional authority.
Right. No, largely. There's certain outer boundaries, hard look, and so on.
Right.
I'll subside.
Yeah. Ken?
Well, I think there may be. I don't know whether there's a debate about Chevron on the court or not. I think there might be. You read Arlington City, which is a case from a few years back, and that's I think effectively a 5-4 decision. It's 5-1-3 with Justice Scalia writing passionately in favor of Chevron. Incidentally, one of the reasons that I loved reading Justice Scalia's work is he could argue so passionately both sides of an issue, right? He wrote the dissent in the Mistretta case, which looked at the structural limitations on delegation to an agency, in that case, the Sentencing Commission, and he was a strong advocate of Chevron in most cases. And the Arlington City case, which was about whether the Federal Communications Commission could promulgate a rule that would override state and local zoning authorities on the placement of cell towers. He wrote a very strong opinion that basically said, well, clearly they can, as if the adverb swept away the dispute. But the dissent written by the Chief Justice for Justice Kennedy and Justice Alito and the concurrence by Justice Breyer all seem to take the position that it's just not straight up logical to say, in this instance, Arlington City, the question was, can the agency in interpreting its statute, its organic statute, is it free to say what the scope of its authority is, and that is only reviewable under a highly deferential basis? And I think the dissent had the better part of that, which is it doesn't make sense to say that the agency gets to say just how capacious its capacity to interpret is. That ought to be for the courts to look at in the first instance, and that's in fact what the Administrative Procedures Act contemplates, and that's what separation of powers contemplates.
So you're making
but it lost.
You're making a distinction between frameworks, the frameworks within which decisions are made, and the substantive content of the decisions.
Right. Yeah. Some people view administrative law as drier than the dust on the high chaparral, and there's something to that if you really want to get into the weeds and ask, what does that executive order from the Clinton administration say about how the office of the OIRA, I can't remember what it stands for. It's the regulatory office within the executive branch. It's going to review every agency. I mean, you can get deep, way into the weeds on this stuff and feel your head hit hard on the desk when you fall into a deep slumber. But the issues that are at stake. No, this is within our purview, and you don't get to second guess what we say about what's within our purview.
Yeah, but there's a couple things going on here, and I think
turns on if it's to be the president.
That Chevron is right. I do want to say, as to certain applications of Chevron, and Jeremy, you picked up on it, I could not agree more that Chevron is misapplied or should not be applied with respect to the Board of Immigration Appeals telling me what an aggravated felony is.
Yeah, I mean, I'm not hearing a lot of disagreement actually between you in terms of what an appropriate structural approach is. Maybe I'm missing it, but
no, he's a sound thinking guy.
No,
so
but the idea is, you assume that we need an administrative state of some kind. We need administrative agencies to do these various things. And they need to be governed by rules and frameworks within which they make rules and so on. But the debate really is how far do they get to go? And how far are they going in practice?
And how much do they get to delegate and subdelegate? And I had an interesting case. I know this isn't the time for war stories, but this kind of put a point on it for me because I was on the dissenting side of an opinion a few years back in which our deference was at issue, and it was an instance in which the Federal Energy Regulatory Commission had delegated its authority to condemn land to a gas company, and the gas company had decided it wanted to replace a gas line, not on the line where it had received a certificate of necessity 30 years earlier, because there was a whole procedure, right? When it's operating the way we want it to, there is this active engagement where the agency has to do notice and comment, and where if it's an individual thing, people have to meet certain hurdles, and the agency is supposed to give it close review. And that had happened 30 years earlier when this gas company said, we want to put a natural gas pipeline in, and they got their certificate of necessity, but now they wanted to change the position of it. And the fight was over what is the meaning of the word replace in the operative regulation, right? And the position that the gas company took, exercising eminent domain power of the US government, delegated by the agency, was replace can mean anywhere. We could do this from Portland, Oregon to Poughkeepsie, New York. It's still a replacement. I'm sure they would say, well, that's a little bit of an overstatement. But I think actually in argument in front of the district court, that was the position that they were on. And the majority in my court said, well, we got to defer to them. It's all good. And I said, I don't think that's, in fact, a fair interpretation of what replace means. There's got to be some locational limitation. And indeed, FERC's own position in an earlier statement indicated it believed there was some locational limitation. But after the district court made its decision, FERC inserted a footnote in an unrelated regulatory finding that said, no, there's no locational limitation. So my point of that long story is, when you're deferring constantly and consistently, you don't have stability because FERC can change its mind like that.
Yeah, so, but again, that's a structural criticism, or it's a structural critique. And I know in just having read opinions, listened to people talking about this stuff over the years, that it's, and I'll go back to a point I made earlier, it's hard to separate it from people saying, you know, I don't like all this overregulation of coal emissions, or I don't like the overregulation of marijuana, or whatever the issue is, that it's hard to separate the substance from the structural problem. And it seems to me that's one of the challenges we have here, because I sense from both of you that neither of you think that the current deference structure is perfect, but how do you talk? We judges do things in the context of cases, and the cases come with certain valences, and so what do we do about that?
This is partly an answer to that question,
Yeah.
but it's more broadly on the scope of and character of federal regulation. Sometimes federal regulation is by design to weaken regulatory regimes, and I'll give you two examples. Number one is the good old Interstate Commerce Act of 1887. It was originally passed with the enthusiastic support of the farmers and the shippers who were being exploited, in their view, by the railroads. The railroads, I think, even at the time of the passage of the Act, knew, and if they didn't know at the time of the passage of the Act, they knew within a very few years that this was a case of please don't throw me in that briar patch, because they captured the agency. And the Interstate Commerce Commission set rates at a relatively high level. It protected the railroads against all of those pesky suits in which they were being, those pesky state statutes in which the rate regulation was always hammering them. And the Interstate Commerce Act protected the railroads. Even though it regulated them, it protected them against excessive regulation, or what they viewed as excessive regulation by the states. Now a purely modern example. California has had for a number of years something called Prop 65 that regulates the use of and publicity about toxic chemicals. Well, we now have a new federal statute about toxic chemicals, which has a much more lenient standard than the state law, and I think Prop 65 is about to be preempted. And federal regulation has now taken place, and you look at that, you might think, oh, all of a sudden this is excessive federal regulation. Quite the contrary. The purpose of the new federal toxic standard is to get the chemical companies out from under the regulatory regime of California.
And that raises a point that we touched on a couple of times earlier today, which is how people feel about the administrative state and the way it's being handled is often dependent on whose ox is getting gored, right? Suddenly, progressives are all about popular constitutionalism now that there's going to be a conservative, quote unquote, I mean, who's to say how conservative in a traditional sense the new administration will be, but now that there's going to be a Republican administration, suddenly, you know, the idea of a powerful unitary executive is a bad thing. Not a peep during the last 8 years, but suddenly, the executive has to be restrained. And there's more than a little bit of irony in that, but it happens on the judicial side too, right? People are, depending on some of their views about what is and isn't the role of government and the role of the various branches of government, they're either all in favor of a very active judiciary or they're not. So you're all in favor of the Warren Court striking down this or that, but very upset when the Roberts Court or the Rehnquist Court strikes something down. And that's kind of unfortunate, because while there's a zone at which politics and constitutional law become almost indistinguishable, right? Where you're talking political science when you're talking constitutional structure. And yet we hold on to and need to hold on to the belief that judges should be just trying their utmost to apply the law in a dispassionate way. And the more the discussion gets into defer or don't defer on the basis of politics, that's kind of corrosive.
Yeah, well, so this is, I think, something that I've certainly been thinking about a lot, and I'm hardly alone. We've had such a corrosive political process in the last several years, I think, without blaming anyone. I mean, I think it's just the nature of it, that it's become increasingly hyper-partisan and hard to kind of figure out where the truth lies, or even if there is truth. This topic we're talking about here, it seems there's an opportunity for the judiciary to think about what type of regulatory structure makes sense, what type of balance makes sense among the different aspects of the problem. So I'm going to ask both of you, what would you do? I mean, if you were in a position to kind of rethink or restructure the rules underlying the administrative state, and particularly the idea of deference and the idea of how much can be delegated, what would you do? How would you come at it?
As a judge, I would do almost nothing. That is to say, if the question is restructuring, I think we are particularly ill-equipped to do that, given the tools that we have. We can do due process, I get that. We can rearrange, we can tinker. We can do a little more deference or a little less deference. We can interpret a statute. I mean, we can do what judges do. We can play around the edges, decide our cases as best we can. But restructuring, I think, is a bad idea. I'll invoke a few cases. All three of us were talking briefly. There's a new debate just emerging because of a decision on the 27th of December out of the 10th Circuit by Judge Matheson, 2-1 decision, in which that court, the 10th Circuit, holds that the ALJs and the Securities and Exchange Commission have to be appointed under the Appointments Clause, that is to say, by the head of the agency, rather than by some other entity, that is to say, civil service. So we have largely independent ALJs deciding questions in the Securities and Exchange Commission. 10th Circuit has just held that that's unconstitutional because they are required to be appointed under the Appointments Clause. They've set up a split with the DC Circuit. The Supreme Court authority is a case called Freitag that I think doesn't really speak very directly to it. Well, that's an example, it seems to me, by very smart judges on the on the 10th Circuit, using highly intellectual analysis and original intent under the Appointments Clause, doing something fundamentally stupid. That is to say, if one of the problems we have with administrative adjudication is that the adjudicators are too tied to the politics of the agency, the solution, and in fact a very well-considered solution, statutory solution, is let's have the adjudicators more or less independent. Well, this is just the wrong answer. But I don't want to confine my criticism to the 10th Circuit. I'd like to criticize the Supreme Court. And that is, I'll take a couple of cases. I'll take first off INS versus Chadha. The one-house veto or the legislative veto was a device employed by Congress to give certain authority, but then to allow the Congress to back off of it. I'm entirely with Justice White, who thought this is working quite well. And for us, the Supreme Court justices, to strike it down based on some theoretical idea of separation of powers and how this ought to work is profoundly misguided. There's a recent article written, well, the consequence has been it's been driven underground, so we now get committee supervision and they hold them to ransom on the budgetary decisions. The Supreme Court using its almost mechanical view of original intent and separation of power, strikes down a very useful device, is now been replaced by something that works much worse and in the shadows. I would also say that Boucher versus Sinar is more or less the same sort of thing. It was a legislative decision. Supreme Court says, sorry, it doesn't work under our view of the separation of powers. If we as judges are intervening based on our notion of separation of powers, given the theoretical tools available to us as judges for historical analysis of the Constitution, we run huge risks of interfering in things about which we know very little, and we're just going to screw it up.
So you're really, what I'm hearing is a traditional common law approach. You prune and you shape, but you don't change the fundamental alignment.
It's a weird thing to call a judge, but I'm Burkean.
Yeah. Okay.
Well, if you were looking for disagreement, you found it.
That's why we invited you.
Because I do disagree strongly with the idea that it's like, who are we to judge?
Yeah.
We're the judges appointed under Article 3. That's who we are, and we're supposed to be policing those margins. We're supposed to be the ones who go out there and see that the structure holds in place. And you could come up with any number of things that are functional, that work, that are useful, which are outside the Constitution. That's not a normative judgment about, that's bad or that's good. It's just a statement that it's outside the structure that we're supposed to be functioning under. That's not unduly formalistic. That's, in my view, being faithful to the law we've sworn an oath to uphold. So I don't fault the Supreme Court for looking at stuff too closely and striking it down. On the contrary, if you can fault them for anything, it's for stuff like Chevron, where they tell the judges, you back off and just let those administrative agencies run with it, right? Because there are places where they shouldn't be running with it. Perfect example of that, in my mind, is Mistretta, which was the case that upheld the sentencing guidelines and the Sentencing Commission, and the one dissent, ironically, was that champion of Chevron deference, Justice Scalia, who wrote a very thoughtful and I thought persuasive argument for why this was delegating lawmaking authority to an agency that had no other purpose than to make law, and that was fundamentally at odds with the separation of powers. And so he took a non-delegation position, that is, that the legislative power could not properly be delegated in that instance. But he was a lone voice on that, right? The rest of the court said, yeah, that's not a problem. And then what happened? Years later, the court figured out, well, maybe it is a problem, right? They realized that having binding sentencing guidelines that judges could not stray from, being established by an administrative body that was stood apart from the federal government, in a sense, apart from the elected representatives, that there was something bad about that. And so in a case called Booker, they did some fancy two-stepping and said, well, that sentencing guideline stuff, that's not really binding on you. It's not, that's advisory only. Well, I can remember at the time, as a brand new lawyer, when Mistretta came out, thinking, how can that be right? And then when Booker came out, thinking, well, I guess they finally realized the consequence of not policing the structural limitations the way they should. So now we're trying to fix it in a non-structural way, but recognizing there's a problem. So when we put our hands up and say, well, this is all just theoretical and formal, I think we're missing something important, which is the theoretical and the formal has real-world consequences, like they did with the sentencing guidelines.
Yeah, so, and I think I certainly had direct experience with that as a district judge, and you did too. We got a question, which I think is a fair one here. So let's say that the answer to this dilemma we've been talking about is more robust judicial review, more robust judicial involvement in these decisions. I don't remember how many immigration appeals the Ninth Circuit has now. I know at one point it was over 10,000. All of us district judges and circuit judges have thousands of Social Security appeals. there are, in the reality of the life of a judge, the things that bubble up from the administrative agencies for us to review are extremely numerous. They have, in most cases, have a lot of technical complexity to them. They're very, very meaningful to the parties. If we were to engage robustly with those cases, we would either be working 25-hour days or we would need many times more Article III judges than we have now. So what do we do about that? I mean, is part of this a resource problem? Because the question that we got was, what about the delay if you were to require this additional layer of robust judicial review? So if it kind of gets to the practical consequences of rethinking some of these things?
I would not be in favor of it, and I don't know many people who would be in favor of saying, for example, that we need now to hire literally thousands of Article III life tenure judges to handle Social Security cases or immigration cases or any of a number of other cases which are subject to administrative review. That's just not, it couldn't happen, it shouldn't happen, and it won't happen. You know, that's like, that we are where we are, right? The administrative state exists in the form it exists, and you can't easily unwind that. But what you can say is, even without saying, well, we're going to have robust administrative review of every Social Security case, what we do have is we have administrative review which follows, just using that as an example, a thoughtful deferential stance. There's a 5-step, well understood, well known sort of, every judge, every district court judge knows it, every circuit court judge knows it, 5-step process that has to be gone through by the agency. You see whether they've done that, and then you ask yourself, is this basically true to the record? And that's all the more review you need to have the comfort that this is functioning in a reasonably good way. But that's a far cry from the regulatory issues that get addressed often with Chevron deference. And Chevron itself famously is set up as a 2-step process. You know, you ask whether Congress has spoken clearly. If it has, that's what controls at step 2. If there's ambiguity, you defer to the agency interpretation. But of course, what you do at that first step, whether you find ambiguity or not, people can be all over the map on that. And they are. You know, when you want to dodge something, you can say, oh, that's ambiguous. Give it to the agency. When you don't, you say it's not ambiguous. And sometimes you just ignore Chevron altogether. In King versus Burwell and Texas Department of Housing in the very recent past, there wasn't a peep made about Chevron. People just went straight on the Supreme Court to an interpretation of the statute. So sometimes that's called Chevron step 0, right? Like, are you going to apply Chevron at all? So I don't think we'd be losing all that much by jettisoning what I view as sometimes the straitjacket of Chevron for a review which is less restrictive. It gives judges more of an opportunity to thoughtfully consider, am I weighing into technical areas where I really can't be helpful, or am I being asked to defer to something which is right in the judicial wheelhouse that we have to deal with all the time, for example, aggravated felony.
So it's rethinking deference in a more pragmatic way.
Well, you know, deference and Chevron deference in King versus Burwell, I think was not a betrayal of Chevron or ignoring of Chevron at all. King versus Burwell, for those of you who don't know, it's sort of Obamacare step 2. Obamacare was saved in an odd sort of way in the first decision, where the Chief Justice writes an opinion for the court saying that it's beyond the reach of the Commerce Clause, but nonetheless the taxing and spending power can save part of it. But King versus Burwell is a second step where the question is, does the phrase in the statute when it says referring to a state exchange also include federal exchange? And the court goes through all kinds of gymnastics to say state exchange also includes federal exchange, and they're right in the sense it was clearly a drafting error, so maybe they should have done it. But on the Chevron point, what the Chief Justice does is to say, and it's absolutely standard Chevron doctrine, you apply Chevron if the Congress indicates that this agency has the power to interpret this statute. And the court said in King versus Burwell, there is nothing that tells us that the IRS was given the power to interpret this statute. So it was fully faithful to Chevron.
Yeah, it's Chevron step 0.
But you can call it Meade, which is another case that tells us what we're supposed to do. But Chevron is actually a fairly disciplined tool, and I think quite properly employed in King versus Burwell.
So you don't, I'm getting the sense, don't think quite as much surgery is needed as Kent does in terms of...
I don't think the court is quite so lawless
Right.
in Chevron deference as was just suggested. Maybe we as lower court judges are, but the Supreme Court, although I find it lawless in many instances, I don't particularly find it so in Chevron.
Okay.
I think Justice Scalia actually spoke on this specific point. I don't think it was in a case, I think it was in a law review article once, where he was saying Chevron works just fine if, as I am inclined to be, you are strict in how you view text and you don't freely find ambiguity where it isn't, right? That may have been why he was comfortable with it. Well, a lot of people are not strict in how they view text. They're a lot more comfortable finding ambiguity where others would say, no, there's not ambiguity. And indeed, the trump card on that is, well, I'm reasonable and you're reasonable, and so if we're looking at this differently, it has to be ambiguous, right? By definition. And so give it to the agency, and that's the problem.
So we have just a little bit of time left. Looking ahead, if there's one thing you could hope for in this period of change that we're about to enter, what would it be? And I'm going to limit you to the administrative law area, obviously, not to things more globally than that. But how can we? I think the whole effect of the morning is nobody thinks we're in some sort of perfect state of being here. So what's a way forward that each of you would be comfortable advocating?
Well, in the first instance, I would think it'd be great if Congress would in fact weigh in on what the level of deference is. Mr. Rosen referred to Senator Lee's pending legislation. That would be very interesting. Of course, then it would, how do you interpret that legislation, and would be an interesting thing. But getting judges to once again look carefully at whether agencies are coloring inside the lines or not, and not having to say, well, I have to defer to you to say where the lines are that you're supposed to be coloring in. I just think that would be a tremendous step, and it's something that actually could be done, and indeed it could be done without the Congress if the Supreme Court were to say, as they could, Chevron is a procedural thing. We're not as careful on stare decisis about procedural cases as we are on substantive law, and this can be unwound. That for the limited things we can do, that would be I think a big step forward.
A clearer roadmap.
Yeah.
Yeah.
What I would like, and I'm afraid this is fantasy land, is a careful, thorough, nonpartisan study conducted by, probably under the auspices of the Justice Department, comparable to the Frank Murphy study conducted under Roosevelt just before the Second World War, to some degree comparable to the two studies conducted under Hoover. Hoover lived for a long time and did an administrative law study under Eisenhower. So that we have very sophisticated careful attention to the whole range of administrative problems, because this is not one simple thing. We've been talking about Chevron just because somehow it's become fashionable in the opinions to talk about Chevron, but that's just the tiniest piece of what's both right and wrong with administrative law. What I would like is a thoroughgoing study of what works, what doesn't work, and do it through an administrative study, or maybe I should say a scholarly and Justice Department study, and then work it through, here's the fantasy land, a functional Congress. But for us as judges to think that we can do the Reformation, I think is just its own form of hubris. We can do what judges do. We can do the fine grain, we can do the review, we can tinker around the edges, we can talk about due process, we can do the fact finding, we can do the hard look, we can do the things that judges do. But to restructure the administrative state, I think, is beyond our capacity.
And that we do agree on, but that's probably why we've talked a lot about Chevron in this session, because that is something that we could do something about. There are limited things that we can do, but that's something we could do.
So I hope, it looks like most people are awake. This subject can get very dry, but I cannot emphasize, and again, I think every judge in the room would agree with me, this stuff is actually really important. This affects the daily life of everyone in this room. I mean, if you receive any government benefits, if you've ever interacted with a government program, this stuff is going on in the background.
And can I make a pitch? We have a long reading list of suggested things. Some of the books are polemical. Some of them are argumentative. But there are two in particular that are just historical treatments that I'd like to give a pitch to. I know neither of the authors personally, so this is not special pleading in that sense. I found two books particularly useful. Daniel Ernst, Tocqueville's Nightmare, Joanna Grissinger, Unwieldy American State. Both of them outstanding works of just pure history, so you know what we've been through, because it helps us understand where we might be able to go.
Well, I want to thank Judge Fletcher and Judge Jordan for being their usual articulate and thoughtful selves, and I'd like to thank our public audience for being with us this morning.
Thanks so much. Thanks, Jordan.